Can you
Yeah,
give us the status? We've heard of various cases that have been filed. Which one are you involved with? What are the core arguments that you're making tomorrow?
sure.
And where do you think this leaves us in this lottery season?
Yeah, yeah. So number one, the proclamation is supposed to expire, and it hasn't been renewed yet, and it's supposed to expire before next October. And so the president is going to have to reauthorize the $100,000 fee. So that's number one. So it could die on its own, but let's assume that it's going to be renewed. So there's two cases, at least two cases. Actually, there's more than two, but I'll talk about the big two. I represent a class action that's filed in the Northern District of California. So when you hear class action, if we were successful tomorrow, I mean, the judge rules in our favor at some point after that, you're probably going to be a class member. And so it would apply to you. That case is called Global Nurse Force Free Trump. There was another case filed in DC. I think it was the Chamber of Commerce. Well, I know it was the Chamber of Commerce, and then American Association of Universities or something like that. And that was unsuccessful. Um, and tough judge, tough arguments. Ultimately, I think a decision that's vulnerable, and they appealed, and they have an argument March 9th on appeal. In between that decision, the Supreme Court came off in the tariff case, and that was last week. And we think that why that's so helpful to us is that this fee really does represent a tax on employers who now want to sponsor workers for H-1B visas. And it's really tough to say otherwise. I mean, yes, they're trying to say that it's a suspension or restriction on someone's entry, but you're really penalizing the U.S. employer who's already paying the fees for the petition. And so it's really not an entry restriction. It's really a tax or tariff to sponsor somebody for an H-1B visa. I mean, that's really a core argument that we're making, and we hope to be successful. Another one we're making is Congress was very specific about certain fees that employers have to pay. I mean, everybody pays an extra $500 unless, well, there are some exceptions, but for a fraud fee, or they
Yeah.
call it the Acquia fee. So you're already getting charged. Now,
And
argument,
dependency fees.
right. And our argument is that, just like the Supreme Court just said, listen, if Congress has been specific and has, you can't just increase the fees on their own. And we know that they have before, but every time the executive agency has changed the fees, they've gone through notice and comment rulemaking. And so one of our arguments is that if you want to change the fees, you can't do it overnight. You have to go through this process, which allows for employers to share their concerns through comments and organizations to chime in. Another one of our arguments, and I think this is what separates maybe us from maybe the chamber case, is we think there's a real problem with how this has been implemented, because the Supreme Court was very, very strict about the president's power to restrict someone's entry. Entry is something that happens at the border, but the way USCIS has done this is they're implementing it at the petition stage,
Right.
which is well before somebody gets a visa, which is difficult. And even when you get a visa, it doesn't mean that you're going to you're not going to enter. By imposing this fee at the front end, this implemented it to charge at the beginning is unlawful. And that's another one of our strong arguments.